Welcome to Noon Wednesday. I'm Marissa Wojcik, multimedia journalist with Here and Now on PBS Wisconsin. Today is July 28th. What happens when a judge offers a defendant alternatives to jail time upon conditions that the judge could change at any time and could keep the case open indefinitely? This is what investigative reporter Phoebe Petrovic set out to answer, along with a team of Wisconsin Watch reporters, upon hearing a number of these cases happening under one Outagamie County judge in a series called Deferred Justice. And Phoebe is here to explain more. And thank you so much for joining us.
Thanks for having me.
I want to just start with, how did you come upon this story? Why did it stand out to you as important to report on?
Yeah, so I was poking around Outagamie County several months ago, talking to defense attorneys up there, asking what it was like to represent clients in front of various judges, because every judge has a particular style. And I kept hearing the same thing over and over again, which was that Judge Vincent Biskupic liked to bring people back to review hearings, or back for review hearings, over and over again after the case should have ended. And a bunch of them said, yeah, I don't know if it's legal or not. It's a little fuzzy, but I didn't do the research on it. And so my first thought was, well, I can do that research and see, if there's any issues of legality or fairness here. And one of the things that really stood out is that judges do, in fact, have some of the widest latitude in Wisconsin among state and county judges in the U.S. But that's mainly in terms of not being bound by sentencing guidelines for particular crimes, not necessarily creating their own sort of path through the criminal justice system, where someone can go to jail, get out of jail, go back to jail again, come out again for the same crime.
Super interesting. So let's break down what's happening a little bit here. First, a person is convicted, and then they are sentenced. Then they go before the judge. This judge, Vincent Biskupic, he stays their sentence, so kind of puts it on hold. And instead of them going to jail, they agree to other terms and conditions determined by this judge. And then they have to kind of continually appear before the court for these review hearings. Is that about right?
Yeah, that's definitely the basic framework. So we were ultimately looking at 50 cases after winnowing this down from thousands of cases. And about half of these followed the framework that you described. So someone is convicted of a crime, or they plead guilty, they show up for the judge to get sentenced. And in all but one, I want to say, of the cases we looked at in this category, people initially were placed on probation with the State Department of Corrections, and then that was revoked for whatever reason. So they violated a rule, they got another crime, they committed another crime, something like that. So then they go before Judge Biskupic, like in any scenario, to be sentenced for their original crime that put them on probation in the first place. And this is where it sort of diverged from the normal process. So Judge Biskupic often said, I'm going to give you, let's say, a year in jail, but if you come back to me in a few months or a few weeks and you tell me that you've been doing well on work release, you've been working as much as you can, you've been attending counseling, you've got your act together in whatever way, I might consider staying that sentence. So often there would be a review hearing several months or weeks down the road. They appear and Judge Biskupic issues a stay or a furlough, which pauses the jail time, lets someone out. They're completely free to live at their home. They're not on a GPS monitor. They're not on work release. And they have to sort of follow the rules that he set. So in one of the cases we looked at, that was going to counseling, maintaining full sobriety, working full time, getting a GED or working on that, and even following a landlord's rules was one of the things that was brought up during those review hearings. And at any point, if they missed a review hearing, they could be subject to arrest.
And so, as you mentioned, you reviewed quite a few of these cases, but so far you've published 2 stories that specifically profiled 2 individuals who wished they had never agreed to this judge's terms. What happened in their cases?
Right. So the first one we profiled was a man named Christopher Cartsunes. He was on probation. His probation got revoked. And so, as I described earlier, he showed up before the judge for sentencing. And he was initially given 12 months in jail. A few months later, he was brought back to court and received a furlough so that he could attend treatment. Cartsunes, a lot of his criminal record stemmed from struggles with addiction and, disorderly conduct or felony bail jumping, things that were definitely the root of that was an addiction that he was dealing with. So he went to treatment, he completed the treatment program, and he stayed for a few months at that treatment facility, even after he had already completed it for aftercare. And over that time, he had to keep checking in with Judge Biskupik, somewhere around 6 review hearings, where Biskupik probed him about his health, about his living arrangements. And eventually, Cartsunes got angry with this judge and this sort of interminable ordeal and accused the judge of harassing him, fired profanities, and he got sent back to jail to serve the remainder of his sentence. And he ultimately wrote a letter to the judge from jail saying, quote, "If I had known you wanted to place me on an indefinite term of court-ordered supervision instead of the agreement we had to dismiss my sentence once I graduated from treatment successfully, I would not have agreed." The second person we looked at was a man named Bo James. Same story, on probation, got revoked, gets sentenced to a year in jail. And a few months later, his attorney files an order for a sentence modification for just time served, saying, you know what, he was revoked on an alleged crime that ultimately had no substance. The DA's office dropped the charges. He should just get out. And instead, what Judge Biskupik said was, "You're not where I want you to be on stability, so I'm going to let you out while holding the jail sentence over your head, and you have to comply with these 5 rules that I set for you, and you have to keep coming in and checking with me." James was in this sort of legal purgatory for 19 months until he said he gave up following the rules. He got sent back to jail, and then he ultimately tried to appeal his case and sue in federal court, which was unsuccessful because he felt that he was placed on an illegal de facto probation.
Wow, lots there, very complicated layers. So there are a few different terms that this judge uses for a practice like this. So probation to the court, or as you just said, from Bo James, de facto probation. Judge Biskupik calls it furloughs. So how is this different from what we think of as regular probation?
So probation is one of the most common ways that a criminal sentence or criminal case gets handled in Wisconsin. And what happens there is that, a judge places someone on probation with the Department of Corrections, and they are free to live in their community, but they have to abide by rules set by the DOC, by their individual probation agent, and by the judge. And if all goes well, this person complies with those rules, they check in with their probation agent regularly, and then they can serve that time without ever having to set foot in jail or prison. There are lots of rules and laws that lay out how probation is supposed to go. It limits how long it should be unless you get extended for very particular reasons. There's a very involved multi-level step process for getting revoked and getting sent to jail. So that's the framework and the basic sort of way this happens. Judge Biskupik's supervision through these imposed and stayed or imposed and furloughed sentences lacked those same checks and balances. So there's no state law that outlines how this can happen. There are some court cases that indicate it shouldn't happen, but they're not binding. So there's really no sort of outside legal framework or guardrails to go by. So Judge Biskupik alone sets how long someone is going to be on this stay or furlough, and for what reason they get sent back to jail. There's no multi-level process with appeals baked into it if he says, you know what, we tried this and it didn't work. The biggest other thing is that there's no supervision by a state agency like the DOC.
So, as you mentioned, you said the word indefinite. So this could potentially go past the amount of time of a person's original sentencing, and in some cases, like how long past their original sentence. And have we seen other judges do this, or is this very unique to this judge?
So we worked with Court Data Technologies, which is a firm in Wisconsin and in Madison that pulls data from all court cases and all judges in Wisconsin. And from that statewide analysis, we ultimately determined that it does happen from time to time, potentially, but nowhere near the extent that it happened with Judge Biskupik. So for cases where probation was revoked and then he was holding review hearings afterwards, in the cases I've described, like with Bo James and Chris Kartsunas, we saw he was holding twice as many review hearings as the next highest judge from 2014 to 2020. So it certainly doesn't happen to the same extent that we could find. This sort of process can entangle people in the justice system for a very long time, because if you aren't successful, then you have to go back to jail. In the same way that if you're not successful on probation, you might end up having to go to jail. So we talked to someone named Charles Joe Reuter IV, who was given 9 months in jail in September of 2015. And he was let out to attend treatment, and he was sent back to jail in early 2018. He would have been finished with his sentence. He would have been free had he just served his straight jail sentence about 2 years earlier. So his case stretched on for 2 extra years. And Chris Kartsunas might have been out, 6 months earlier if he had just sat his straight jail sentence, so on and so on.
So it feels like you're just kind of at the whim of the judge, and it's hard to know. Did nobody intervene on behalf of these defendants? Did they have attorneys? Did anyone else see that this is something to look into?
So one thing I will say is that it wasn't well known in Outagamie County that this was happening in Judge Biskupik's courtroom. So there were people in the Outagamie County criminal justice system who had no idea that this was happening. And most of these people, everyone had an attorney when they were going through the initial conviction and sentencing process. Most often the public defender's office stops representing people, after they get sentenced. They're stay on for a particular period of time, but it might be something like 20 days, and then the case should be over because the person should be serving their sentence. There's no need for an attorney, presumably. And so in some cases, people were just left without attorneys to deal with this on their own. And there were a few instances we found in which a public defender or a district attorney's office or the defendant themselves did object to this ongoing supervision or object to the jurisdiction at the beginning outright, but those weren't particularly effective, and it still continued in those cases for the most part. We only found one person who tried to appeal the actual stay, and that was Bo James after he was sent back to jail. His attorney believed that the supervision, or that rather during that 19-month period of supervision, Judge Biskupik's jurisdiction or his official authority over the case had expired. But in that case, the defense attorney said he had no idea how long the case was going to run for. And so it might have been a sort of a wasted effort to appeal to the Court of Appeals, because by the time they saw the case, he was out of jail.
In kind of the larger national context, there's been a lot of discussion about criminal justice reform and reforming the carceral system in general. Not putting people in jail and kind of throwing away the key, trying to actually, make people better, restorative justice, things like that. Does anyone see what the judge is doing as a good thing? This is an alternative to jail time. He's trying to help them get over addictions. He's trying to help them find jobs, get education. Are there people who defend what he's doing?
Yeah, so we spoke to a couple of people who were actually subjected to these arrangements. A woman in particular named Kristen Gerholt, who really appreciated what the judge did and said that it was unusual, but that she felt like it helped her. In her case, she had to write a letter to her son. In another case, we heard, I was grateful for the chance to go to addiction treatment because, you're sober in jail, but you're not actually going through therapeutic treatment. One of the big things, though, the big differences is that in a formal treatment court, they use a medical model. There's national standards that they adhere to, as well as state standards. And every person who goes through treatment court has at least a 3-person team of a project coordinator, a program coordinator, the judge, a probation agent perhaps, and their treatment provider who's helping that person along. Whereas this was just the judge saying, you're in jail, go find treatment and I'll let you out. So there aren't as many supports. But I talked to a judge in Brown County who said that he was familiar with so-called probation to the court from as early as 50 years ago, who said, I use this in a very limited fashion when someone, say, was convicted of driving with a revoked license. And rather than telling them they need to go to jail, I say, I'll stay that jail time and let you get a driver's license and come back to me in 6 months, show me you have your license, and then we can consider the case closed. And that was sort of, people saw that as an effective way to handle something that perhaps didn't need to be in the criminal justice system at all. The big thing is that you need guardrails and supervision in order to make sure that that this tactic is being used in a constructive way, was the criticism that was raised.
And it's interesting, you spoke with a lot of legal experts, judges, to get their opinion on have you used this? Is this legal? And some defended it. And 2 quotes that stood out to me were, one said, this is part of his inherent power of the court. And then another judge said that he has absolute immunity when performing official duties. Do circuit court judges have this much authority? And as you said, there aren't checks on it. So is it technically legal, the amount of authority that he is asserting in his courtroom?
So we talked to something like 26, 28 legal experts, and the opinions were super mixed. So I can't weigh in on whether or not it's truly legal, but so in terms of inherent power of the court, that's a term that kept coming up, particularly from judges whom I spoke to, who were in favor of this sort of disposition. And they said, courts have to be able to do what they need to do to, resolve a situation, particularly if the legislature hasn't mapped out exactly what needs to happen. So the legislature isn't, holding the judge's hand while they're writing, so to speak. The judges do have some control over what sentences they choose. Other people said, inherent authority, whatever you may have as a judge, is still bound by the parameters of state statute and case law that's set down by the Supreme Court and the Court of Appeals. For instance, there should be sort of like maximum penalties for crimes, and you can't go over that for, just because you want to do that. So it is sort of limited. the absolute immunity when performing official duties quotes actually comes from a magistrate judge who threw out Bo James's federal lawsuit. And what that means is that, similar to the way that police officers often have qualified immunity and are basically immune from prosecution while they're acting as police officers, judges have the same thing. So in that case, because Bo James didn't argue that Biskupik was acting extrajudicially or, completely outside of the bounds of just what a normal judge would do, the case got thrown out. But as I mentioned earlier, the Court of Appeals did have a case in 2000 that was looking at something very similar to this. A Barron County judge stayed a sentence so that a person could get addiction treatment. And in that case, the Court of Appeals said, actually, the case law and the statutes don't support this, that, a judge can't act on his own authority to create de facto probation. That was the quote in that case. And that doing so is more akin to the power of the governor to, issue commutations or pardons. And so that's a question of sort of separation of powers. But that case was not published, so it's non-binding. And, it doesn't require judges to abide by that way. And the rule of appeals is that if no one appeals the case, that's it stands in that case. And as I said, none of these cases have been appealed, so the rulings stand.
What is Judge Biskupik's response to all this? Is he still doing this in his courtroom? How does he defend himself?
So we didn't get to talk to Judge Biskupik directly. We were communicating through his private attorney for the majority of the case. He provided a statement in which he said, I have presided over close to 1,000 or maybe more than 1,000 cases. I'm forgetting the exact number, could be 10,000. He's presided over thousands of cases. We were looking at 50. He said that they mostly resolved between 2015 and 2018. We did find some review hearings that were happening even into 2020 during the pandemic. But it's unclear whether or not he's continuing this practice because he would not answer that question. Judge Biskupik said that none of his cases have been overturned in the appellate courts, which is true, and said that he considers all methods available for sentencing, including options of getting people into treatment.
So, understanding all sides of this, some are in favor of it, some are not. It's a legal gray area. Did you speak to any legal experts or did any ideas about what kind of reforms might be needed in light of what's happening in this Outagamie courtroom?
So some people who saw a potential benefit to this particular solution or to this particular arrangement suggested that, the state legislature take a look at codifying this because by codifying it, you're not necessarily endorsing the practice, but rather providing those guardrails in case it happens in the future. One defense attorney had a beautiful metaphor. He talked about what Judge Biskupik and attorneys who are agreeing to this arrangement, what they're doing is sort of like creating their own paths through a park, maybe going off of the paved sidewalk, and they're trampling on the flowers right now. And if the legislature looks into sort of paving that new path, that sort of desire line through the park, it might work out for everybody. There might be people who get to avoid jail time, but who aren't necessarily subjected to potentially years of supervision without any clear answer as to when it'll end. So that was the biggest thing, was potentially the state legislature could look into examining and then laying out what the actual parameters should be, just like we have that for probation.
A lot of excellent reporting so far. Are there more stories to come in the series?
Yeah, so we'll be covering two of the major themes from our reporting in the upcoming series. So one of them is how Judge Biskupik used review hearings to monitor payments of costs, fines, fees, and restitution. This is something that's Ordinarily, the clerk of courts handles a civil authority that doesn't have the power to jail you or arrest you. And the second part that's coming out in the next few weeks is looking at how Judge Biskupik often ordered people to go to addiction treatment, and how that compares with established treatment courts.
We'll keep an eye out for those. Phoebe Petrovic of Wisconsin Watch, thank you so much for joining us.
Thank you for having me.
For more of Phoebe's reporting, you can visit wisconsinwatch.org. And for more from Here and Now in PBS Wisconsin, you can visit pbswisconsin.org/news. And thank you so much for joining us today on Noon Wednesday.